Today we are discussing about the specific and often misunderstood legal issues that arise when government employees lose their seniority either because of an interdepartmental transfer or because of errors in the preparation of gradation lists, two of the most common causes of service law litigation in India today. Hello friends, I am Advocate Sudip Patra, practicing in the Supreme Court of India and the Calcutta High Court. Over the course of my practice in service matters before the Calcutta High Court, the Central Administrative Tribunal, and the Supreme Court, I have seen that seniority disputes consistently cause the most distress among government employees because the consequences are irreversible if not challenged in time. A wrong seniority position compounds year after year, denying promotion after promotion, and by the time the employee approaches a court, decades of career damage have already occurred. Let us begin with the concept of gradation lists and why they matter so much. A gradation list is the official ranking of government employees in a particular cadre or service, and it forms the basis for every promotion, empanelment, and posting decision. Under central government rules, a seniority list must be prepared by the cadre controlling authority in accordance with the applicable recruitment rules and the Central Civil Services Seniority Rules 1981, and it must reflect the inter-se seniority of all direct recruits and promotees correctly. The list passes through stages: provisional list, then objections are invited, then a final list is published. The critical point that most employees miss is that the window to file objections to the provisional list is the most effective stage to challenge errors because once the final list is published, the procedural bar rises significantly. If you receive a provisional seniority list and your position looks incorrect, that is the moment to act. Prepare a detailed objection with documentary support, get it notarized if needed, and ensure you receive acknowledgement of its filing. The second major topic for today is inter-se seniority, meaning seniority among employees appointed in the same batch or year. This is where the Rota Quota rule becomes decisive. When a cadre has both direct recruitment and promotion channels filling vacancies, the recruitment rules fix a ratio, say 75% direct recruitment and 25% promotion, or 50 to 50. The seniority list must be prepared by applying this rotation cycle to the vacancies filled in a recruitment year, not by simply ranking people by date of joining. The error that departments frequently make and that leads to CAT litigation is that they prepare the list purely on the basis of date of physical joining without following the prescribed rotation. The Supreme Court, in a series of judgments, including Bimlesh Tanwar versus State of Haryana and subsequent decisions, has held that the Rota Quota rule must be applied in its true spirit, and if a department deviates from it in preparing the gradation list, the list itself is liable to be set aside. The third and most practically important issue is what happens to seniority when an employee transfers between departments. For central government employees, the DOPT has issued comprehensive office memoranda on this subject. The broad rule is as follows. If the transfer is on the employee's own request, his seniority in the new cadre will be fixed at the bottom of the batch he joins, or at the bottom of the year's direct recruits. Depending on the new cadre's rules, his previous seniority does not travel with him. However, if the transfer is in the public interest ordered by the government without the employee's request, the terms of seniority must be clearly stated in the transfer order. And in the absence of any such stipulation, the employee's previous seniority must be protected as far as possible under the rules of the new cadre. Courts have held that silently resetting seniority to zero in a public interest transfer without any rule authorizing such action amounts to a violation of the employee service rights and is amenable to challenge. Beyond this, there is also the issue of notional seniority, where an employee's seniority is fixed for all purposes from a notional date earlier than his actual date of joining in the new post to give effect to a court order or to correct a historical injustice. Understanding whether your transfer order provides for notional seniority is critical and often requires a careful legal reading of the transfer and appointment orders. Finally, I want to address the question of limitation and delay in these matters because this is where cases are most commonly lost. For central government employees approaching the CAT, the limitation period for filing an original application is generally 3 years from the date of the cause of action, meaning the date you came to know or ought reasonably to have come to know of the wrong seniority fixation. In practice, this means the date the provisional or final seniority list was published and communicated to you. Filing a representation does not automatically suspend the limitation period, though courts have sometimes condoned delay where a genuine and bona fide representation was pending. For High Court writ petitions, there is no fixed statutory period, but courts apply the doctrine of laches and will refuse relief where there has been unexplained delay. The message is simple: the moment you see an incorrect seniority list, consult a service law advocate, file your representation, and keep track of the timeline.